Well, good morning, everybody. Bright and early for one of the most interesting topics to do at 9 a.m. in the morning. Thank you for joining. I'm Francisco Servent with Keystone Law Firm. And today you're going to get to hear from one of my favorite people, my partner, Michelle Dexter, who's been with the firm. I think we've worked together for about 8 years now.
That's correct.
And Michelle she leads our estate planning department. And today, she's going to share some good information with you guys. Michelle is one of the most clear educators about complex topics that I've met. And what's really great about how she works with our clients is it's not just dumping information at you with overwhelm. She really does have a heart of wanting to make sure you get it. And that's what you're going to walk away with today. So if you've been wanting to know how to do this, what you should do, how all this stuff works, you're in the right spot. I think you're going to walk away with a couple aha moments. And that's really our first goal for today, is that you walk away saying, I get it. Now I know something more than I started with. And you can take that and apply it to your life. And that's our biggest first goal. Obviously, our second goal as a business is, if you're looking for help with this stuff, this gives you a very low pressure way to learn about us, hear how we do things, and kind of evaluate whether you think it would be a good fit for you to work with us on this if you need some help. I do know some of you are already clients, and I love that you're here. There's nothing better than learning about this stuff over and over and over again. As we all know, that the best way to learn something is through repetition. And so come back to these webinars. We have a whole bunch of them the rest of the year. Learn these topics over and over again, because the more you know, the more you hear, the more you can just, not even without even thinking about it in your life, go, oh, this might mean I need to call and ask if I need to make a change or something. So I'm glad you're back. I'm glad you're here. And I know you'll learn something new today. So with that, I want to hand it over to Michelle and take it off, Michelle.
Thank you so much, Francisco. Everyone, I'll just give you a warning. This is my first webinar. I've done some live seminars before, but this is my first webinar. So I appreciate your patience with me. And if I'm not always looking at the camera, it's because I got some notes over here and I got my iPad down here to kind of draw you some things. And I'm going to do my best in the hour that we have to give you some hopefully really good information about estate planning here in Arizona and the purpose of the trust and the alternatives to a trust. Okay. One thing many of you who are my clients know, I work in worst case scenarios. Our litigation department handles some of the uglier sides of estate planning. And so on the estate planning side of it, I like to utilize those lessons to really help clients understand the decisions that they're making and make the best decisions for themselves and for their family. Okay. So people often ask, why do I need a trust? I don't think I need a trust. There's other ways to do it without a trust. And so I like to kind of start with a visual. Okay. And so hopefully you can all see that black screen. And I'm going to draw 3 boxes. Okay. Most of your assets, if it's not in a trust, are probably in your name, right? You got bank accounts, your house, those types of things. And that's typically where most people keep their assets. Some people will have some assets that are in their name with a beneficiary. And typically those are your retirement and your life insurance type of accounts, right? So starting with the things that are just in your name, okay? Things that are in just your name are subject to probate. Okay, if you pass and you have an asset that's still in your name here in Arizona, that is subject to probate. Okay, recently they changed some of the laws with regards to probate and here in Arizona and what we call a small estate affidavit. They've raised the limit for what a personal property small affidavit requires. And so if you have an asset or all of your assets that are in your name at the time that you die have a total value of less than $200,000, your family can receive those funds with what we call a small estate affidavit. Okay, now there's a couple of rules when you're using a small estate affidavit that can complicate things. One, they have to wait until 30 days after your passing to execute that. Two, all of your beneficiaries, all of your heirs have to be able to sign off on that small estate affidavit. So if you have a child that's not in communications with the rest of the family, if you've got somebody who's been missing, we can't fill out and complete that small estate affidavit without everybody signing off. Okay. Another thing is that the small estate affidavit signed under penalty of perjury, and it says that all of your creditors have been paid and all of your final expenses have been paid. Oftentimes your family is waiting to access those funds in order to do that. And so it's kind of a catch-22 of I can't pay off those bills until I have access to the money, but I can't get the money until I pay off the bills unless I go through probate. Okay. When it comes to a piece of real property, that limit has been raised to a value of $300,000. Okay. That requires 6 months to pass after your death. Okay. And so for a lot of families, maintaining that mortgage, paying the taxes, the homeowner's insurance, the HOA fees, and keeping that house in good condition for 6 months after you pass can be burdensome on them. That does require, that real estate, small estate affidavit does require being filed in court before the transfer can be made. And similar to the personal property small estate affidavit, it does require that all the beneficiaries sign off. So that is not always the best opportunity for each family. Sometimes that can run into a lot of complications. And so we've seen that. So even if the amount is smaller, that small estate affidavit doesn't always necessarily work. One of the bigger things that I worry about, though, when we're talking about things that are just in your name, is our ability to access them during your lifetime. Okay. Incapacity issues is something that I think is a little bit newer to this generation. I feel like when our grandparents and our great-grandparents became senile, we just moved them into the house. We went down to the local bank. Everybody knew us. Everybody knew the family. And we just were able to access things and move things in a different way than we are today. So things that are still in your name during your lifetime require what we call a power of attorney. Okay. And a power of attorney is a relatively simple document to sign. You name who your agents are. You decide what kind of authority they have over bank accounts and government benefits and all the different things. But what we find with the powers of attorney is that the banks have a lot of discretion in whether or not to accept them. Okay. They will refuse to accept them because the document has become stale. Our rule of thumb is that every 5 years, we are updating documents here at Keystone for our clients, whether we're making any changes or not, because we want that to be a fresh document. Okay. We don't want the banks to think that there might be a newer document out there. I've heard that some banks will do it as soon as 2 years. They'll consider it to not be a fresh document anymore. They'll consider it to be stale and they'll refuse to accept it. I've also had banks refuse to accept financial powers of attorney because of language that was in it or wasn't in it. For example, I had one situation where a family went in to use mom's power of attorney. Husband had just died. And they said, well, there's language in here about if she got divorced, a certain thing would happen. And even though we know that her husband just died, we can't ask her whether or not she's divorced because that's a privacy question. And so we're not going to accept the power of attorney. I had another case where a couple had been married for 50 years. Their documents were about 20 years old. Wife was incapacitated in a facility, and husband needed to pull a little bit of money out of her IRA account. He provided the power of attorney and they said, wow, this is really old. We're not going to accept it. Okay. The problem with them not accepting your power of attorney is that the alternative is a conservatorship. Okay. A conservatorship is a person appointed through the court to make financial decisions for you. All right. The biggest problem with the conservatorship is the cost. Okay. It's going to cost money to have the conservator appointed because your family member is probably going to have an attorney. The court's going to appoint an attorney for you. There's going to be a court investigation that happens. There's going to be a court hearing that happens. Conservatorships often cost a minimum of $10,000 to get going between all of the parties and all the court fees and everything. Okay. In addition, Your conservator, once appointed, has to do an inventory of your assets. They have to provide the court with a budget. And then every year they have to provide the court with an accounting of how your money was spent. That accounting is reviewed by a court accountant. And then there is a hearing to approve the accounting each year. When you pass away, the conservator goes back to court again to do a final accounting, to do a proposal of where the distribution of funds are going to go to in terms of, is it going to a probate? Where is it going? And then they have to close that conservatorship, okay? Conservatorships also typically require a bond. A bond is like an insurance policy that says that your conservator won't run off with your money. So that's another cost annually that goes with that, okay? So it's really important that when you have assets that are still in your name, that your power of attorney is always up to date. You're reviewing that periodically, making sure that the people you've named are accurate, that they're still able to act on your behalf, and that your power of attorney is not too outdated, okay? Those are the biggest concerns that I have with those things that are just in your name, right? The assets that are in your name but with a beneficiary, right? We avoid probate there, right? Which is great. But we're not avoiding is the need for the power of attorney and the possible conservatorship, okay? Now, there are some assets that we can't change out of your name during your lifetime. Your retirement accounts, your IRAs, your 401ks, those things have to be in your name during your lifetime. So it is important that you're making sure that your power of attorney is always up to date, because if you become incapacitated, let's say that you need to go into long-term care or you need more medical care and your family is looking to use those funds to pay for those expenses, they need to be able to access that account to pull more money out. That power of attorney is what's going to be utilized if we can avoid the conservator. All right. Let me see. So let me just check my notes and make sure. So let me talk to you a little bit about also what a court probate looks like for those assets that are in your name. A court probate can be one of two ways. An informal probate is where everybody's on the same page. We can get everybody to sign all the documents we need. We send it into court with all the paperwork, and they send it back to us without a court hearing, okay? That process is usually about 2 to 4 weeks after we get everybody to sign off on all of the documents, all right? If we have an issue where we can't get everybody to sign off on the documents, I did a hearing yesterday where we couldn't find the original will. We can only find a copy of the will. That is going to require a court hearing. Most of those court hearings are at least 6 to 8 weeks out from when we file for them, okay? I have seen them as long as 3 to 4 months out, especially when we get towards the end of the year, when the court's dark for a couple of weeks. And so all of those things can negatively impact your family's ability to access those funds after you're gone, to be able to pay for the expenses that they need to be paying for and taking care of those types of things, okay? Let me see. The other thing that I have concerns about with those assets that are in your name but with a beneficiary designation is, what are the contingency plans available through those retirement accounts or through those life insurance policies if your beneficiary is not alive? You know, if you've named your kids as beneficiaries of your retirement account, but one of them's not alive, what's going to happen with that person's share? Is it going to be given to their children? You know, is there a box that says that it can go per stirpies and continue on to their children? Is it coming back to your other children? Is it coming back to your estate and having to go through probate for you? And so that's one of the other things, is that, you know, there's limited contingency plans when it comes to those things, right? Now, I've also seen where a lot of people think, well, I don't need really a fancy estate plan. I'm just going to name my kid on my account, or I'm going to add my child to my house, right? That also can come with some problems, right? Because one, again, there's no contingency plan. If something happens to you and that child who's named on there, we're still running into the same problem of a potential probate, okay? But also, sometimes when we're naming people on these accounts or on pieces of real property, that can trigger a gift. That may trigger a gift tax return. It may not actually result in a gift tax, but there are different things that happen, okay? In addition, that child could lose the stepped up basis on that house and cause them to have to pay additional capital gains on the property, okay? Let me see if I can come to a clean sheet here. Okay, so for example, your house, right? If you bought your house for $100,000 and now it's worth $600,000, okay? That's a $500,000 gain, right? Less the exemption for living in there is what you would have to pay capital gain taxes on, right? When you add a child on or a beneficiary onto your house, onto your deed during your lifetime, they are getting the basis at $100,000, okay? If you still own your house and your child inherits your house at the time of your death, their basis becomes the date of death value, okay? So if they turn around and sell that property, say within 6 months, there's no capital gain tax for them, all right? That can be a huge difference in how that asset gets handled. And while you think that you just saved yourself the trouble of a probate, you may have cost your child a lot of money in terms of capital gain taxes in that regard, all right? So there are definitely some issues with that. I met with a family this week that when mom bought her house, she put her only daughter on the house because she wanted to, have that as part of her estate plan. And now she's at a point where she's probably going to have to sell the house and move into a facility. And so we're left with the question of, do we transfer daughter's interest back to mom? Is that going to trigger some kind of gift between the two of them? Do we let daughter keep her half interest in the house, and when the property gets sold, she gets half of the proceeds but has to pay a capital gain tax on her half of the proceeds? Or do we try to figure out something different, right? And so it's not really working out the way that mom originally planned in her head of what was going to happen with this house. And so I just like to warn people, you got to be careful when you're just adding people onto it. If you're adding a child onto your bank account, for example, that child doesn't necessarily have an obligation to share what's in that bank account or to share the proceeds from this house with your other beneficiaries. And if you say to them, I'm going to leave everything to you and I want you to divide it out amongst the other kids, now we may be creating a gift between the child that's on the account and all the other beneficiaries. Today, the gift tax amount that you don't have to file a gift tax return for is $19,000 per person. So if it's more than $19,000 per person that this person is giving a gift to based off of your instructions, that may be triggering a gift tax return for that child that you added to your account. So there's just some different things with regards to that people aren't aware of necessarily. And we want to make sure that they're thinking all the way through. I like to call it an educated choice. It may still be your choice at the end of the day, but you understand the risks that you're taking by setting it up in this way versus through a different way, okay? So coming back to my little chart, right? The third bucket is putting assets into a trust, okay? Now, when you are creating a trust, you are what we call the trust maker, right? I like to think of it as like a triangle, right? The trust maker is the rule maker, okay? That's you to begin with. Only you can make the rules with regards to the trust. You decide who the beneficiaries are. You decide who the successor trustees are. You decide how your beneficiaries receive their assets. Are they receiving it outright? Are they receiving it in a protected subtrust? Are they receiving it only for certain purposes? Can they only receive it for education? Can they only receive it at certain ages? There's all kinds of different things that you can do, right? You also get to decide what are the contingency plans. Yes, first it's going to go to my kids. Do I want it to go to my grandkids then? Do I want it to go to a charity? Do I want it to go to a niece or nephew? Where do you want the money to go? And so I work in worst case scenarios. So I always have my plan A, my plan B, and my worst case scenario. And so the trust allows me to get that deep in terms of what is going to happen with your funds if plan A doesn't work out. What's going to happen if plan A and plan B doesn't work out, okay? Initially, when you create a trust, you are also the trustee of the trust, okay? Now, I refer to the trust maker as the rule maker. I refer to the trustee as the rule follower. The trustee is the person that follows the rules that you've set up for the trust, okay? And so they administer the trust based off of those rules, all right? At some time in the future, this trustee becomes someone else, right? And that's the whole purpose. That's the whole purpose, because when we're using the trust, we don't need a power of attorney and we don't need a conservator because we've got a successor trustee. And by having that successor trustee, we're taking the discretion away from the financial institutions, okay? They don't have the ability to say your trust is too old. They don't have the ability to say we don't like who you've named as successor trustee, or we don't like language in there. They just need to see, is there an incapacity or is it death? And who's the named successor trustee, and did they accept that role? Okay, so it really helps avoid a lot of the court stuff, okay? Not only during your lifetime, but after your death, because trust assets don't go through probate court for probate either. So we're avoiding a conservatorship, we're avoiding a financial power of attorney issue, and we're avoiding the probate, all right? The third portion of my triangle is the beneficiary. And initially, you are the beneficiary of this trust, okay? We will be using your social security number for the trust. All income flows through your trust to your personal income tax return. So it's not creating something complex. It's not creating something different. For most banks, you can go and you'll change the name from your name into your name as trustee of your trust. A lot of banks allow you to continue using your same account number. So you can still continue to use your checks, use your debit card, use everything you need. But once it's titled in the name of the trust, if there is some kind of issue in the future, your successor trustee can come in and take over that account, okay? And a lot of times we can have that account taken over within a week or two, okay? With the right documentation, you know, if it's a claim of an incapacity, I need to see a doctor's note, a doctor telling me that you're incapacitated. If you've passed away, you know, then we're completing the documentation to give to the bank based off of that situation. And the banks at that point in time are just updating the account, okay? They're not having to evaluate the financial power of attorney to determine whether or not they're going to accept it. They're just processing the affidavit for the successor trustee, all right? And what I find with a lot of our trust administrations, especially if we've got something where it is an only child, right? We are able to transfer those assets to that only child in a very quick and expedient manner. You know, depending on how much they know about your finances, if they know I've been taking care of mom already, I already know what her creditors look like. I already know what her expenses look like. And I can say to them, if you want me to transfer the house to you today, I can transfer the house to you today. If you plan on keeping the house, we can transfer that type of thing. So it eliminates a lot of the things that we have to wait through court to get permission for, because the the trust happens all outside of the court, okay? Eventually, you are not the beneficiary, right? And so, again, that gets, you know, to the people that you've named in terms of who's going to be the next beneficiary. But when we're looking at, and let me clear up some room here. When we're looking at the trust, no probate, no power of attorney, no conservatorship, okay? And so that is why, especially here in Arizona, the trust is generally the better way to go, because it eliminates that discretion that other people have to manage things. So things like your house can go into the trust, your bank accounts can go there, your life insurance. I can't get rid of the requirements for for the retirement, right? The retirement accounts, I don't have any control. That's a federal mandate that those be held in your name during your lifetime. But now we've limited what assets we need to access through that power of attorney. Okay. And so we've minimized the risk because the majority of other assets are being held under the name of the trust. All right. One of the great things also about the trust is the ability to do what we call special planning. Okay. Special planning. If you have a beneficiary who's under the age of 18, in assets in your name and assets with a beneficiary named, those institutions are going to require, or the probate is going to require, that a person under the age of 18 have a conservator appointed to them for us to distribute. Okay. If it's in the trust and you've named a grandchild to receive some assets, your trustee who you've named is going to manage that for them. And you get to direct what are those funds being used for until they turn a certain age. At what age maybe can they have it outright? At what age could they be their own trustee of their own subtrust? Do we want to limit it to educational purposes until they're 25? Do we want to limit, put any other kinds of restrictions on it, right? And so when we've got somebody who's a minor child who's under the age of 18, and we've seen this repeatedly, we had a case a couple of years ago where uncle left his nieces, both under the age of 18, as a beneficiary on his life insurance and on his retirement accounts. Neither of those assets had to go through probate, but neither of those companies would distribute to the minor children without a conservator in place. So we went to court. We got the children's parents named as their conservators. We got the money released, but guess what? The court doesn't want the conservators using the money for the kids when they're under 18. So those funds now go into restricted accounts. And guess what? It's really hard to invest those types of accounts in something other than possibly a high interest savings account, because the court doesn't want you risking the kids' money, right? And I understand that. I completely agree. But if you've got somebody who's going to have their money being held up for 10 years, you'd like something more than 3% interest. At least I would, and some of the courts are starting to open up to that, but through the trust, again, that's not overseen by the court. Your trustee has a fiduciary duty to your beneficiaries, right? So they can't go and invest in some crazy IPO, or they can't go, do something really crazy, but they've got a little more flexibility in how they can invest those funds. Okay. Now, special planning also can happen for incapacitated adults, where similarly, we're having somebody else oversee those funds for them. But one of the things that I feel like I'm running into more and more right now is where we've got beneficiaries that are receiving government benefits, whether they are on the spectrum, whether they are disabled, whether they have some kind of other issue, right? And a lot of times these can be older kids that are receiving it, and sometimes they're younger kids that are receiving it, okay? When you are receiving government benefits, you do not have the option of saying, no, I don't want that inheritance, okay? You don't have the ability to disclaim it, because the government wants you to use your own money. Right? And so if you have money available to you, they're not going to be like, yeah, just say no to that money and keep spending ours, right? They're going to want you to take that money. But if anybody has any experience with trying to qualify for government benefits, right, it is one of the more painful things in life. The number of hoops you have to jump through, the stress that's caused by having to answer questions and provide the documentation and do all those things in such a short period of time, right? So the last thing we want is for these people to lose their benefits, spend down the inheritance, and then have to go back and requalify for the benefits, okay? And so if we don't set them up with anything, sometimes there are what we call first party special needs trusts that those funds can go into, okay? That's something that has to be approved by the court. And those first party special needs trusts, and it's a whole nother topic. We'll talk another time. I just want to give you kind of the brief overview. But those special needs trusts, those first party ones, require reimbursement to the government for the money that they've expended from the trust when you're done with the trust money. Okay. When we're setting it up through a trust, we can do it as what we call a third party special needs trust, which does not require reimbursement to the government and allows your trustee to manage the money for that beneficiary who's receiving benefits. I like to think of it as quality of life money, things that the government can't pay for or doesn't pay for, that you can't pay for yourself because you don't have the income to do it, right? But those are some of the types of things within a trust that we can be planning for your beneficiaries, watching out for those future generations. You know, I've got two great nephews now that were both diagnosed with autism. And so I'm already talking with their parents about, you know, how you set it up for you. But in addition, if you think your parents are going to want to donate to their grandkids, we may need to set up something separate for them to all put in, right? And so sometimes you're just looking at like your immediate, these are my kids, they're all fine. But what if it accidentally rolls over to your grandkids? Are we preparing for them? Are we making sure that we're not, money's not going to come to them that's going to disqualify them from benefits that they need in order to progress? Because, you know, if they receive this money and they have to spend it down and then requalify, it can really delay things for them. All right. So we definitely want to make sure that we are taking care of not just your kids, but also your grandkids. And I have had a number of cases recently where their child has been on disability and has been receiving government benefits for years. And then mom dies, and now this child's going to receive money, and all the siblings are trying to figure out how can we prevent them from getting the money because it's going to disqualify them from their benefits. But had mom taken that into consideration when mom was still alive, we could have resolved it, you know, type of thing. And so unfortunately, they're not coming to us until after they've passed. And of course, we weren't the ones that did mom's estate plan to begin with. But, you know, when these families come to us after the fact, our hands are tied in terms of what we can do, because we are not in a position to, you know, defraud the government. That's not really what we do. What we do is strategize with the rules that the government gives us on the front end of things. And so it's important to take some of those things into consideration, because many people are just looking for the simple way to avoid probate, and they're not necessarily thinking of all the different factors that can impact how their estate plan might go and might, you know, turn things differently than what they're expecting it to happen. Okay. So that's kind of my summary in terms of using a trust versus not using a trust. I think that here in Arizona, it's a little bit different than a lot of other states. I know a lot of times I hear people that in other states, they don't need a trust. My uncle passed away in New Jersey. And when we were back in New Jersey, this neighbor lady came by and said, "Oh, you just take the will to this window at that building and they'll give you all the paperwork." That's not how it is in Arizona, you know? And so, you know, when you're talking to your friends or family that are out of state and they're like, "You don't need a trust, that's unnecessary," come to Arizona, come deal with the probate system here, and then make up your mind, because it's a different beast here. Okay. Francisco, do you have anything you want to add before maybe we take some questions?
Just on your last point, I think is a really important thing to emphasize, that Arizona, I think the reason why Arizona is a little different than a lot of other states is because we are such a big retirement state, and we have a lot of people move here to retire. We have a lot of people move here to our wonderful weather and the amazing state that we have, to enjoy that, you know, the stage of their life. And since we have so many retirees, our state laws are set up in a really strict way to protect against exploitation. of vulnerable adults. And it, as much as our laws are set up to be very protective, it still does happen sometimes. But because we have very protective laws about that, it changes how we address things here. So what I've seen, and we've seen this a bunch of times, where those laws that are set up to protect vulnerable adults, one of them, which a lot of people don't know exists until they get thrown into the mess, one of those laws actually makes your bank, your financial advisor, and your CPA, it makes them something called a mandatory reporter. And we may have heard that term used in terms of like CPS or schools. If they see a bruise on a child, they have to report it. They don't have a choice. Well, banks, financial advisors, all these institutions that deal with money are mandatory reporters of anything that meets, that's the long list of suspected exploitation. And it can be triggered by something as simple as, you go into the bank, you are elderly at this stage in life, and maybe you have a child or grandchild with you, and they're there to help, truly. But maybe you're wanting to give them a gift because they want to pay a little credit card, or you just want to give them a gift and it's a few $1,000s or something. If the person sitting with you from the bank feels for whatever reason that interaction needs to be reported, they are required to report it to Adult Protective Services. And that's a department of our government that does fall under the law enforcement section. So it's part of the police department. They essentially have all the police powers. And they are then required to investigate. And if they don't come quickly to a very satisfactory answer that convinces them there's no shenanigans, then they can launch at their own discretion against you a full court lawsuit, a conservatorship that freezes your assets, that puts somebody else completely outside the family that you don't know, that you've never met before, in charge of all your money. I just got a call from a client. It was on Thursday, and it came through as a message to me, but it was like an emergency. Something's happened, blah, blah, blah. And I got the message. I said, this is an emergency, called him back. And what happened was a family member told him that a bank had called Adult Protective Services because of exactly that scenario. Family member went with another family member to the bank, and behind their back, the bank reported this as suspected exploitation to Adult Protective Services. And thankfully, he's a client of ours, so he called, he said, what do we do? And I said, here's what you do. A, B, C, D. And I talked to him a couple days later, talked to him on Monday, and he said, thank you so much for telling me what to do, because we told them exactly what you told us. And they said, sounds good. You guys are taking care of business the correct way. A few years ago, completely different scenario where somebody wasn't a client of ours, but we got a call, and I think this was right before you started, Michelle. This was years and years ago. And the call was a little different. It was, I need help from a lawyer. I don't know what to do. I just got handed paperwork saying that the court is freezing my accounts, and I have to be in court tomorrow at 11:30 a.m. to dispute this. That was the message I got. So I call him back quickly. I say, what's going on? And I went, I know exactly what's going on as soon as he described it. And I said, let me meet with you in the morning. Let me go to court with you. And at that point, it was too late. So what happened in that scenario is APS was called by the bank, completely unknown to this guy. APS had gotten a lawyer, a completely unknown fiduciary company. They filed a lawsuit in secret. They got it all arranged so that at 11:30 a.m. that day, if he didn't have everything presented to the court saying, defending everything, that at 11:30 a.m. the court was going to freeze his assets and put this fiduciary in place. Well, by the time it came to us, by the time we got to court, I went and argued, and the judge said, you know what, I'm just going to take the most protective measure here, and I'm going to appoint them to be in charge of your life. And it's going to be on a temporary basis. Temporary was 6 months. And over that 6 months, they put a babysitter in his house. They froze all of his assets. They literally locked his life down. And this was a guy who was just living in peace on a golf course in Mesa, was, having like the last of his life, just enjoyable. And as months went on, he had to go through doctor's evaluations and neurology evaluations and all this stuff so we could try to prove he was fine. And as this court thing dragged on, his health just declined. And by the time we got our opportunity to present everything, he actually passed away. And so the whole thing didn't go away. It essentially destroyed his life. And then, after the fact, after he passed away, we were just wrapping up the court case because there was nothing else we could do. And these third-party companies that he never knew before, were nowhere involved in his life before, they get to ask the court to be paid out of his estate, and they did. And their fees totaled about $120,000, and the court approved it. And his estate was a paid-for manufactured home on a golf course in Mesa, which was worth about $200,000. And he had about $250,000 in his nest egg, retirement account, savings account. That was it. This was not a complicated estate. This was not like somebody worth millions and millions of dollars. And they walked away with over $100,000 in fees, and in my opinion, completely destroyed this guy's life. But it's that type of thing in Arizona that just motivates us to tell these stories, get this information out there, so that like Michelle said, the potential impact of your decisions, right? We're not here to make decisions for anybody. Like, this is your life. Life is a do-it-yourself game. But the more we know about the impact of our decisions, the better we can live with them, right? The more we know is always better. So I want to hammer home that point that Arizona is a little bit unique in this regard. And so that's why, in all reality, a living trust is basically the new way to create your will. And it's not any harder. It's the same kind of decisions, but you're just thinking it through a little bit more, and you're putting your things in place that you will carry things out how you wish they would. We all want this stuff to be simple. And I wish, if this were 100 years ago, like Michelle said, right, we just all walk into the bank and go, yeah, this is mom, this is dad, this is brother, this is sister, here we go. But the way our society has gone, the way the laws are written, the way lawyers love to file lawsuits, the way government has grown, all of these things just make it so that it's not that simple anymore. But what's cool is you can make it that simple again.
Yeah.
That's really cool. Like, you still have the ability to make it that simple, and that's why we do things the way we do them, where we can tell our clients, all right, this is going to be about as simple as possible. When either you have that medical emergency or you pass away, and your family will say, good, this is simple, thankfully, yay. Yes. So it's a huge gift. We all love our families. We all love our the people in our lives that are important to us. And as much as I would love to wave a magic wand, and Michelle wave a magic wand and say, poof, it's no longer required. This is one of those things that is part of showing our family that yeah, I did this. I did this for you. I like I did everything else for you in life. You know, I raised you and your little babies, and I took care of the stuff and whatever. This is one more thing that we do now as that person who's protecting our families.
Yeah.
There are a couple questions in the chat, Michelle. So
Most definitely. I'm going to answer kind of the first two together, I think. So if you have documents in another state, okay, those are given full faith and credit in all U.S. states. All right. So you don't necessarily need another trust. But what we recommend is that you're reviewing your trust every year, every 2 to 5 years, right? And making sure it's still working the same way, right? When you go to update your trust, you're going to want to probably change the laws so that it's governed by the state of Arizona instead of the state of California. Okay. That's not a huge change. And so it's not something that we're like, get in here today, it's got to be changed. But it is something that when it's time to update your trust, whether you're changing your agents or just, incorporating all the recent law changes, any of those types of things. Your financial and healthcare powers of attorney are what we call state specific. Okay. Now they will be given full faith and credit if they were created in another state and you are now in Arizona and they were created legally in that other state. They will be given full faith and credit here in Arizona. But if you are making Arizona your legal home, or if you're making another state, you did them in Arizona and you're making another state your legal home. In general, what I recommend is that you are consulting with somebody locally because those state specific, so like where we are required to initial in our healthcare power of attorney may be different in another state. And when you're having a medical emergency, I don't want the medical staff at that hospital or at that facility saying, is this a valid document? It doesn't look like all the other ones that I see here in the state of Wyoming, And so again, it's not the first thing you need to do when you move is get a new document. But again, these documents are not documents that should sit on your shelf for 10 years. You should be reviewing that, every couple of years and updating them accordingly. Okay. Now, if you have in your will, like most trusts are coming with a pour over will, right? A pour over will says, look, if I miss something, it needs to go into the trust because all my contingency plans are in the trust, right? So if you have a will that names your trust as the beneficiary, yes, you still need to transfer assets into your trust because one, the will is the directions to the court. Okay. So that means you're going to probate and that's the way that those assets are getting put into the trust. But also during your lifetime, those assets are still in your name. So we're still running into the problem with the power of attorney and the conservatorship. So it's almost like you've created a trust and really minimized the benefits of it by not titling your assets into the name of your trust. Okay. How is the step-up basis for investment accounts handled if they're not in the trust? Francisco, I might let you speak to this. As far as I'm concerned, they're handled the same whether they're in the trust or not in the trust. But you do a little bit more on the financial side. I don't know if you have anything that you want to add to that.
Yeah, so the trust doesn't change the step up in basis at death tax result. So whether it passes through probate, whether it passes by beneficiary, or whether it passes through your trust, it all passes through that same step up in basis result. So no difference between trust or a beneficiary designation or something like that. It is different if it passes, if you have joint with right of survivorship or community property right of survivorship or some type of right of survivorship. That can be different because the result there is something that was transferred partially or in some percentage during your life. So there was some portion of it transferred during your life because then it's joint. Okay. So that is different, and that's not as good of a tax result. They'll pay higher taxes in that scenario than they will under a trust or a beneficiary just directly. So it is different in that scenario.
Yes. So Peggy asked about taking her house out of the trust and would that be bad? Now, I will tell you that a lot of times when people go to refinance their house, and if it's in the trust, the mortgage company will be like, we can't make you a loan if it's in the name of the trust. It's going to have to be in your guys' names as individuals, right? What they fail to tell you is that you should follow that up with a beneficiary deed. And a beneficiary deed says that at the time of your death, it's going to become a trust asset again, and it passes outside of probate. So it kind of falls into that middle bucket there of in your name, but with a beneficiary designation. And a lot of times that's the only way that you can get a loan against the house or a HELOC or, refinance or those types of things. So is it bad? I wouldn't say that it's bad, but you have to make sure that you're following up with making sure that there's a beneficiary deed being placed on the property if you're taking it out of the name of the trust. Okay. What paperwork or process do we need to put the assets into the trust names? In our office, there's a 2-page document called a certification of trust. It provides the banks or the financial institutions with all of the information they need, who the trust makers are, who the trustees are, what the tax identification number is, what the title of the trust and how to title it in, the name of the trust. And so that is generally the paperwork that we send clients off with to go have something put into the name of the trust. Now, I will tell you that, these big banks, they run by their own rules. And so they may say to you, we need a copy of the signature page of the trust. We need a copy of the beneficiary section of the trust. I can't control what those banks do. Our trust language for the trust that we create say they can rely on that certification. They really don't need to see anything else. And I think a lot of times it's kind of funny because you could come in the next day and change that provision and their information would be outdated. But at the end of the day, sometimes banks require stuff, and I don't ever tell you, don't work with that bank. I just tell you it's up to you. You decide what banks you work with and what rules they give you and whether or not you're willing to comply with them. So, but that's kind of my long short answer is it should just be the certification of trust, but sometimes they ask for additional things. Yeah. LLCs. Yeah. LLCs are great. You generally name the member of the LLC as the trust and the individuals as the managers. Okay. So, you and your spouse are the managers. It's your trust as the member. Something happens to you and your spouse, the successor trustee is able to name a new manager. Okay. And so that's kind of how you do that on the back end of those LLCs is make sure that the trust is the member / owner of the LLC. And then the property is still owned by the LLC. The bank accounts can be titled in the name of the LLC, those types of things. Okay. So yes, the LLC is part of the trust by the trust being named a member through the Arizona Corporation Commission type of thing. Okay.
There's a couple people who use the video system to raise their hand to ask a question. I'll ask you guys to go ahead and if you can just type it in the chat, just because of the microphone system, it gets goofy and I don't want to mess up the audio for us. So a couple of you guys did raise your hand. If you have a question, just drop in the chat and we'll keep chewing through them. We've got a few more minutes.
And great questions, guys. I mean, I love
great questions.
Yes.
So, and just so you guys know, if something here prompted you to think like, okay, I need to do something here. We have 2 ways that we start with new clients. Some people are like, I'm ready to go. I just need to know what to do. So if you want to, you can schedule a call with our client intake specialist, Alexis. He's great at just like getting you going, and there's no cost for that call. You can schedule it any time, and he will help you figure out, what the starting point is, and then you'll take care of payment, and then you'll meet with Michelle or I, and then we'll refine the plan with you and decide, do you like hamburgers with cheese and lettuce, or do you just like it plain? And anyway, we work from a menu-based option, which is all flat fees, so you don't ever get surprised by nickel and dime charges with us. If you're not quite sure what you want, you're not quite sure about your situation, you feel like you want to sit down and have some more time to just really dive in privately, one-on-one with myself or Michelle, we do 1-hour consults. They're $400, and we will go through your exact situation. So we can talk about anything. We'll help you figure it out. We'll help you make a decision and move forward. And if you choose to move forward the same day as the consult with the package that you pick, then that gets credited towards our services to create your living trust, your plan, whatever all the package of documents is that you want. Our estate planning packages, they range from about $2,000 all the way up to $15,000 of our flat fee services. You know, a lot of the simplest families, they are right at that $2,000. It's when we start talking about more asset protection, more tax strategies, more just interesting things that clients want, where we get towards that higher end. But that's the range of fees that you would be looking at for us. But those are the two ways to move forward if you're ready to do that. And look, you're here because you wanted to learn more about this. I would say the biggest number one problem that we run into, that we see, is waiting to get this done. It's not anything else. We get called all day, every day, all year, just all the time about families who are dealing with the death of a loved one, and it's a mess. And I can't tell you, almost every single time, not every time, almost every single time, the kids or the wife say, we've been meaning to do this. We've been talking about doing this. We even went to a seminar, we did a whatever, but they just didn't use the momentum to get it done. So the way we work, like I said, it's flat fees. We always recommend get your first plan done, get it done simply, quickly, whatever you think is complex holding you up, get something done, because you can tweak it over time. And even for us during the first year, you can make an additional change for no extra cost. So no pressure to stick with something, but getting that first plan done is such a key step in this whole process. So,
and the biggest compliment I usually get is, this was so much easier than I thought it was going to be. You know, like you guys helped me get through the things that I was concerned about, you know, and so that to me is like great, because it's not intended to be difficult, scary. Like, you know, I get it. There's some decisions to be made, but let us help you with making those, because I think that when you start to have conversations around who is the right person to make some of these decisions, it becomes a little clearer. You know, Steve, you asked about when your doctor asks you for your about a healthcare power of attorney. You're welcome to give them a copy of it. It may be enough for them to know they're just, you know, trying to take note of that, but you're more than welcome for any of the people that you normally regularly see to provide them with copies of those documents. Yeah.
All right. Well, we are about out of time, guys. Thanks for coming.
And Alexis put in that scheduling link. If you want that free discovery call with him, that link is in the chat. Alexis has been here probably
4 years.
Yeah, he's been here a while, so he definitely knows a thing or two. So he's a great person to do that. Thank you, Peggy. We appreciate, you know, that compliment. And yes, as Shiloh mentioned, here in Arizona, they have the Healthcare Directives Registry that allows us to take your healthcare documents and register it with the registry. All the major hospitals have access to it. They're expanding it to medical doctors and medical clinics. So if there is an emergency, they should be able to pull up that information. And Steve, you may be able to say to your doctor, yes, I do have them and they're registered with the registry. Do you have access to the registry, doctor?
Exactly.
And turn it back on them. So like, I did my part. Are you doing yours? So
bingo, bingo. All
yes,
right.
and for those of you that are clients, we have all of your documents scanned. So if you ever need us to email you just those limited documents, let us know. We're happy to email that to you, and you can just forward it on to your doctors. Okay. Thank you guys all so much. I know sometimes people say it's like, when I'm talking to them about this stuff, it's like drinking through a fire hose. And I know there's a lot of information, but it really, really is important to me that I feel like people are making educated choices when they're making decisions around their estate plans, because so many times in law in general, whether it was when I was doing family law or estate planning, it's I wish I had have known, that ends them up in a situation that they're not happy with. And so now hopefully you know more than you did when you first arrived today.
Absolutely. Thanks, Michelle. Great to see everybody. Have a great day,
We
guys.
appreciate you.
Bye-bye.
Have a great day. Bye.